They thought I was finished. They sat across from me at that long oak table in the mediator's office, and they actually smiled. My son-in-law had this way of tilting his chin up just slightly when he felt like he'd already won. I'd noticed it years ago at the dinner table whenever he'd gotten his way about something. A restaurant, a vacation, which contractor to use on the deck. Small things, but I'd always noticed it. That chin, that quiet, unbothered confidence of a man who had never once in his adult life been truly surprised by anything. He was doing it that day, and my daughter was sitting beside him with her hands folded in her lap like she was in church. I am 63 years old. I spent 31 years as a civil engineer with the province of British Columbia. I built my house with a mortgage I paid off 11 years early. I drove the same truck for 14 years before I bought a new one, used, because the old one finally needed an engine replacement, and it didn't make economic sense anymore. I raised 2 kids mostly on my own after my wife, Patricia, passed away from a brain aneurysm when our daughter was 9 and our son was 12. I did not complain about that. I did not ask anyone for help I didn't need. I kept going because that is what you do. I am telling you this not because I want sympathy. I am telling you this so you understand who I am. So you understand that when I say I knew something was wrong, long before anyone said a word to me about it, I mean it. Engineers do not guess. We calculate, we observe, we account for variables other people ignore. I had been observing for about 8 months before it all came apart. It started the way these things always start, quietly, without announcement. My daughter Sylvie and her husband Brett had been living 40 minutes away in Langley. They'd been married 6 years. 2 kids, both under 5. Brett worked in commercial real estate. Sylvie had taken time off from her job as a dental hygienist after their second was born and hadn't gone back yet. I understood that. Kids are expensive and daycare in the Lower Mainland is. I don't have a polite word for what daycare costs in the Lower Mainland. About 2 years ago, Brett started coming around more, which I should have been glad about. He'd never been particularly warm toward me. Civil enough, but the kind of civil that costs a man nothing. He'd started calling me on Sunday afternoons, asking about the house, asking whether I'd thought about downsizing, asking, carefully, gently, always very gently, whether I'd updated my will since Patricia had passed. I told him yes, I had. It was none of his business, but I told him yes. Then Sylvie started coming around separately, without Brett. Just her and the kids on a Tuesday or a Saturday morning, which was lovely. I'm not saying it wasn't lovely. I missed her. After Patricia died, I think Sylvie and I both retreated a little. Grief does that, pulls people inward, and we'd never entirely closed the distance. So when she started showing up with coffee and muffins from that bakery in Abbotsford she knew I liked, I was glad. The first time I noticed something off was in November. She was sitting at my kitchen table while the kids played in the yard, and she said casually, "The way you say something you've been rehearsing so long, it finally sounds casual." "Dad, have you ever thought about putting the house in a family trust?" I looked at her. "Brett was reading about it," she said. "It's a way to protect assets for the grandkids." I said I'd look into it. I didn't look into it. I called my accountant instead, a man named Gerald, not my daughter's accountant, mine, a man I'd been working with for 19 years. And I told him what she'd said. Gerald was quiet for a moment, and then he said, "Don, don't do anything yet. Let me ask around." Gerald asked around. What he found was not a family trust consultation. What he found was that Brett had been meeting at least twice with a financial planner in New Westminster, the same financial planner who had some years prior helped a family in Abbotsford restructure an elderly parent's assets in a way that, and this is Gerald's word, legally disadvantaged the parent significantly before they passed. I sat with that for a while. I want to tell you something about being 63 and realizing your daughter and her husband may be engineering a way to take your house out from under you while you're still living in it. It doesn't feel the way you'd expect. You don't feel rage right away. You feel something quieter than that. You feel a kind of cold, tired disappointment that sits in the back of your throat. You think about the muffins from the bakery in Abbotsford. You think about those Sunday phone calls. You think about your son-in-law asking about your will with that careful, gentle voice, and you feel like an idiot for not seeing it sooner. And then you stop feeling like an idiot and you start thinking clearly again, because that is what you do. You account for variables. You keep your face neutral. You keep going. I told no one. Not Gerald, not Beyond the Basics, not my son Marcus, who lives in Halifax and who I talk to every Sunday. Especially not Marcus. He worries about me. He would have called Sylvie, and it would have been a disaster. I kept it to myself, and I started paying attention in a different way. The next visit, Sylvie brought over a man she introduced as a friend of Brett's. He was a notary, she said. She said he was just stopping by, that Brett thought it might be helpful to have a conversation. I offered the man coffee. We sat at my kitchen table. He had a folder. He started talking about powers of attorney, about how straightforward it was to set one up, about how many older homeowners in BC had done it to make things easier for their families down the road. He was very professional. He used the word planning about 14 times in 20 minutes. I asked him one question. Who would be named as attorney? He said. Sylvie and Brett, jointly. I said I would think about it. After he left, I walked out to my backyard and stood there for a long time looking at my vegetable garden. I built 3 raised beds the summer after Patricia died. Tomatoes, carrots, beans. I've added to it since. There's a dwarf apple tree in the corner that I grafted myself from 2 different heritage varieties. It took 4 years to produce fruit. It produces the most beautiful apples you have ever seen in your life. I thought about that apple tree. I thought about how patience is not the same thing passivity. And then I came inside and I called a lawyer. His name is Philip, a litigator I'd worked with briefly years ago when a subcontractor dispute had gotten ugly. He remembered me. I told him everything. He listened without interrupting, which I respected. When I finished, Philip said, "They haven't actually done anything illegal yet, Dawn. What they're doing is called positioning. They're building towards something. The question is whether we get ahead of it or respond to it." I said I wanted to get ahead of it. We spent the next 3 months building what Philip called a paper record. I documented every visit, every phone call, every mention of the house or the will or a power of attorney. I had my GP perform a formal cognitive assessment, Philip's idea, not mine, and the results were filed and dated. Perfect marks. Sharp as I'd been at 40. I updated my will with Philip's office, transferring nothing, changing nothing about the structure of the estate, just updating it so that the date stamp was recent and unambiguous. I had a frank conversation with my bank about any joint account activity or account restructuring requests, and they flagged my accounts for a secondary review process if anyone other than me made changes. Then I waited. In February, Brett filed a notice with the BC Supreme Court requesting a hearing under the Adult Guardianship Act. He and Sylvie were applying to be named my co-guardians on the grounds that I was showing signs of cognitive decline and was unable to manage my financial affairs independently. I found out from Philip, who received a copy of the filing. I sat in my truck in my own driveway for about 20 minutes when he told me. Just sat there. The radio was off. I could hear the neighbor's dog barking somewhere. I thought about Sylvie at 9 years old, crying at her mother's funeral because she kept thinking she had to be quiet. I had held her hand the whole time. I had told her it was okay to cry, that crying was not weakness. I had held that child's hand. Then I got out of the truck and went inside and called Philip back and said, "Tell me what we do next." The hearing was scheduled for a Tuesday in late April at the Vancouver Law Courts on Smythe Street. I drove myself. I wore a suit, navy blue, the one I bought for Marcus's convocation. I had it dry cleaned. I shaved carefully. I arrived 20 minutes early and sat in the corridor with a cup of coffee and my notes. Philip had told me what to expect. There would be an appointed representative, a sort of neutral assessor, who would review the petition and speak with all parties. Brett and Sylvie would present their case first. Then Philip would respond. The judge, a woman named Justice Hartwell, would review the medical and financial documentation and make a determination. Brett and Sylvie arrived together. She didn't look at me in the corridor. He did. He gave me that look, not unkind exactly, but the look of a man who has already closed the deal in his mind and is just waiting for the paperwork to catch up. That chin, that stillness. I nodded at him. Inside the courtroom, their lawyer laid out the case. He talked about phone calls I had apparently confused. He talked about a conversation in which I had supposedly forgotten that I'd already spoken to Sylvie earlier that week. He talked about my age and the natural cognitive changes that accompany aging, and he said it respectfully, framed as concern, framed as love. He described a man who was slipping, who needed guidance, who might benefit from having family take a more active role in his financial decisions. Sylvie sat very still beside Brett. She kept her hands folded in her lap. She was wearing a gray cardigan I'd given her 3 Christmases ago. When it was Philip's turn, he didn't raise his voice once. He introduced the cognitive assessment, dated, signed, administered by my GP, with a copy verified by a neuropsychologist at Lionsgate Hospital. He introduced the documentation Philip and I had compiled, every date, every visit, every phone call, the meeting with the notary, the financial planner in New Westminster. He introduced a letter I had written to Justice Hartwell directly, which she had received 10 days prior, and which she confirmed she had read. In that letter, I had described in detail the sequence of events from the first conversation about a family trust to the power of attorney visit to the guardianship filing. I had included a timeline. I had included Gerald's notes. I had written it the way I would write a report for the province, clear, factual, referenced. No emotion, no accusation, just the record. Philip also introduced one more piece of documentation. He had obtained, through proper legal channels, a copy of the communication between Brett and the financial planner in New Westminster. In that communication, Brett had outlined a proposed restructuring of my assets in the event the guardianship application was successful, a restructuring that would have effectively transferred the equity in my home into a holding structure with Brett as the controlling trustee under terms that would have been very difficult to reverse. This was not the plan of a concerned son-in-law. This was the plan of a man who had been building towards something for 2 years. Justice Hartwell read for a long moment. The courtroom was very quiet. Brett had stopped, tilting his chin. He was looking at the table. Sylvie looked at me for the first time. I don't know what she was looking for. I looked back at her and I didn't look away, and after a moment she did. Justice Hartwell denied the guardianship application. She was direct about it. She said the medical and financial record presented no evidence of cognitive decline, and that the documentation suggested the application had been filed not out of genuine concern for the respondent's welfare, but in pursuit of financial interest. She said she was referring the matter to the Law Society for a review of the legal advice given to the petitioners. She also noted the financial planner's involvement and said she would be forwarding documentation to the relevant regulatory bodies. She looked at Brett when she said the last part, not at his lawyer. At Brett, he didn't look up. I signed a few forms with Philip afterward in a small room off the main corridor. Philip shook my hand and said I'd handled myself well. I thanked him. I meant it. Then I drove home. On the way, I stopped at the bakery in Abbotsford and bought myself a coffee and a butter tart, which is something Patricia used to say was the only pastry worth eating in the entire province of British Columbia. I sat in the car in the parking lot and I ate it and I thought about things for a while. That was 4 months ago. Sylvie called me once about 3 weeks after the hearing. She didn't apologize exactly. She said she hadn't understood what Brett had been planning. She said she thought it was just about protecting the family. She said she was sorry things had gone the way they had. She cried a little. I told her I loved her. I told her I needed time. I still need time. That's honest. Marcus came out from Halifax last month, and we spent a week together. We put new trim on the back porch, and he helped me winterize the garden beds. In the evenings, we sat on the porch with beer and talked the way we used to when he was in his 20s, before life got complicated and busy. He didn't bring up Sylvie. I didn't either. We just sat there in the quiet, and it was enough. The apple tree produced its first fruit that week. Marcus tasted one and said it was the best apple he'd ever eaten in his life. I told him that was because I'd been waiting 4 years for it to be ready, and some things you simply cannot rush. He laughed at that. I did too. I am still in my house. It is still my house. The raised beds are already planned for spring. I'm adding a fourth this year, pole beans and a heritage squash variety I found at a seed exchange in Chilliwack. My truck runs fine. I see my grandchildren on Sylvie's custody weeks when she can manage it, which is not often, but we are working on it. Slowly. I am 63 years old and I am not finished. Not remotely close to finished. They should have known that from the start.